Well, welcome back to Key Point here on TV3. We're live on 3FM 92.7. Also live on TV3 Ghana on Facebook, DSTV channel 279, all across the world on 3news.com. Investigative journalist Aremeyaw has stated his intention to appeal the High Court's decision in a defamation case he lost against Asin Central MP Kennedy Agyapong. In the statement, Anas expressed disappointment in the judgment of a defamation case he filed in 2018 following pronouncements by Kennedy Agyapong made against him after airing his number 12 investigation into football and related corruption cases. The judge, Justice Eric Barr, described Anas' investigative style as investigative terrorism and concluded that the MP was justified in his assertion in using the descriptions Anas was seeking relief for. Anas has since stated he will appeal the judgment on the grounds that Kennedy Agyapong's allegations that he was a murderer were not proven in court. And that is what you've heard, in fact, you saw in the videos that we played earlier. But Kennedy Agyapong and Kwesinyan Chechi, who was also in court, have also been talking about the outcome of this particular ruling. And in their view, what this means in Anas's modus operandi, which is the basis for the judge's pronouncements. I'm going to welcome my guest now. Honorable Nelson Raxon Dafiamepo is Member of Parliament for South Dai constituency. He is a private legal practitioner as well. Also, Honorable Alexander Akwesi Akwa is Member of Parliament for Achim Oda constituency. And Martin Pebu is private legal practitioner. He is the leader of one of 3 individual bondholder groups, and then also the convener of the Kome Preko Reloaded demonstration. I would also be joined later by Manasseh Azore Awene, who is an investigative journalist, editor of The Fourth Estate. But gentlemen, good morning, welcome.
Good morning.
Great. I'll start off with you, Honorable Alexander Akwesi Akwa.
Alfred, I thought we were going to add that also a media practitioner.
I'm so sorry. Forgive me.
It is the reason I'm so interested in this.
Indeed.
In this topic.
He is not you were or you still are.
Well, once a soldier, always a soldier.
You have a fiat of the speaker to practice your vocation.
Well, as we sit here,
has he got the speaker's fiat?
As we sit here, we are all practicing media.
So he is a media practitioner.
No, we are participating in it. We are not practicing it.
Yes, a media practitioner, by the way. And thank you so much for adding. Let me start off with you on this. I mean, how this case has traveled and the ruling a couple of days ago and the reactions thereof, even before we get into the specific aspects that Anas has raised concerns about. Honorable Akwesi Akwa.
Well, good morning to your cherished listeners and viewers, as well as my co-panelists, who all have serious legal backgrounds. I want to tackle this issue from the perspective of an ordinary Ghanaian and perhaps a former media practitioner, somebody who has done media for close to about 15 years, produced shows, and the fact that I have some form of admiration for colleagues who have chosen to do investigative journalism. This case, as been pronounced by the revered judge last week, brings to the fore discussion on the Anas principle. The Anas principle. This is a principle that has been espoused by two presidents. I mean, you have two presidents recommending that principle. You have the late president, Aremeyaw, going to the SEP's headquarters on the basis of an expose from a colleague or a friend, Anas. And if you heard the late president speaking, he didn't believe the video, or he didn't believe a lot of things that had been said about workers or staff of customs until he saw a particular video from Anas. And that pushed him to go to the SEP's headquarters. I tried to watch the video again. I think TV3 had the video. And if you heard and saw the passion with which the late president was speaking, you would realize that he had believed in the Anas principle, and he felt that it was a good thing to do, and perhaps that had unearthed some of the things that we had always believed or thought of. The current president, during an IEA discussion, also mentioned his effort in fighting corruption using the Anas principle. And so it tells me that something had been introduced in the fight for corruption, the fight against corruption, and in our media practice that we call the Anas principle.
Indeed.
So is the Anas principle the normal investigative journalism that we know? Because there have been a lot of investigative journalists in the past. You have the Kofi Kumsins, Kweku Bako himself, the famous Kwesi Pratt. I mean, back in School of Journalism, we revered people who did investigative journalism because we felt that they end up becoming heroes because they go underground and unearth the kind of things that perhaps will help society. And so those of us who would do normal journalism, political journalism, entertainment journalism, when we see investigative journalists, we had always seen them as people who had actually gone beyond a particular mileage in the practice of the profession. Now, having talked about the various people who have hailed the Anas principle, we know of cases, we know of a lot of issues that had been dealt with using the Anas principle. And a lot of Ghanaians had actually hailed the Anas principle. Talk about the case of the judiciary. You know, you don't want
biscuits.
to, the orphanage, the orphanage. I mean, these are cases.
NGFA.
These are cases that everybody hailed Anas for, because this is something we knew. This is something we had thought of, but we didn't have evidence. And so the Anas principle now becomes an evidence-based investigation that unearths some of the things we have always thought of, imagined, suspected. And then he goes underground and brings them up with evidence. Now, he does that by putting some of the people, some of the corporates on camera without they knowing. You know, because we know that a lot of people are engaged in some ills of society to an extent that even if you are dealing with them without they seeing the orthodox camera that we know, but perhaps you have a hidden camera on yourself, they will go open and talk about it freely because it's become their daily routine, what they do every now and then. And so Anas had used some of this method in bringing some of these issues up. And then we had the famous Nyan Techi case and others that became a bit controversial. I mean, there are some of his recent exposés that at the end of the day, a section of the people will be happy, others will feel maligned, others will feel victimized. And so we had the Agyapong jumping in and, I mean, extending the issues beyond perhaps the normal practice of Anas and making statements that led Anas to the courts. So for me, this case is bringing to the fore the discussion of what the Anas principle had been. A principle, like I said, that had been held by Ghanaians, a principle that two presidents had alluded to, that this is the best way to fight corruption. Because we know, we have ideas. I mean, we always hear that this is happening in this particular sector. This ill is happening in this particular sector. But it takes somebody to go underground to bring up the evidence and get us discussing it. You dare not say that the judiciary is in bed with some corrupt deals. The accounts will say, "We are then Kase Okonfo Esiko." The Okonfo is a fetish priest, and by virtue of what they do, the cola they chew and the kind of concoctions they drink, they normally have very discolored
Tinted teeth.
But you dare not say it. You see it because it is in his practice that gets his teeth discolored. So people have enormous powers. People have enormous strength in their practice of profession, of their various profession, that could be abused. But you dare not. I mean, everybody. There are people who knew the fact that you can't have the judiciary being so straightforward. But it took somebody to go with the goats and have a judge taking it, and it's on camera and all that. Now, at the end of the day, others would say that this expose actually reduced the kind of integrity Ghanaians and the kind of confidence Ghanaians had in the judiciary. But it was relevant then to let that institution set up, because these are things we had always suspected. But somebody had to sacrifice to bring it up. Now, the sacrifices of this same person had gone to an extent that it's attracted a lot of condemnation because of this ruling, because this ruling had given Ghanaians another side of the Anas principle. The fact that it is not everything that he captures that he shows, and that there are some negotiations here and there that leading to the judge making pronouncements that sort of impugns on the integrity of Anas and his practices. I think that going forward, we would definitely want to look at the judgment and then bring out the issues. And as we do that, we do not have to discourage investigative journalism. We will be dead if we dare go that way. We will definitely be dead as a nation if we go that way, because we know that investigative journalists, I mean, there are some who would practice the same profession, I mean, investigative journalism, without necessarily covering their face. And these people had actually achieved some feats, making sure certain people who were placed in certain essential positions have been exposed, and they've lost their jobs here and there. But Anas' practice, Anas' principle is such that he always have to cover himself, and that is what makes people think that there's something behind the veil, and perhaps this judgment had come to expose. It's early days yet. We will still want to interrogate the ruling and see exactly. But for me, the investigative journalist would need some form of protection. We do not have to destroy that aspect of our journalism.
This is from a man who was and is still a media practitioner, but now a member of parliament. Let me also welcome Manasseh Azure Awuni, who is an investigative journalist, celebrated one for that matter, and then also the editor of the Fourth Estate. Manasseh, thank you so much for joining us on Zoom.
Thanks for having me, Alfred.
Great. And then also to put out a caution again for those of you who intend to step out of home. It's raining heavily in most parts of the capital as we speak. And then also there's been an accident around the Tetekwashi interchange heading towards the airport area, which has created heavy vehicular traffic. And so please, yes, if you know the other alternative routes, you can use, that is the Jawulu side, and then still connect to Kaukodi, and then you can continue your journey. But as we speak, there's heavy vehicular traffic as a result of an accident around the Tetekwashi interchange heading towards the airport first junction. So that is the information for you, our viewers, and our listeners on 3FM 92.7 as well. Just for the uninitiated, we have aspects of this ruling. In fact, this is a 65-page ruling by Justice Aremeyaw. So we definitely cannot get into all the issues that he raises, but also make reference to specific aspects. And we'll put that on the screen right now, some of the portions of the ruling by the judge. He says that, quote, that Aremeyaw Anas is engaged in what he described as investigative terrorism. And we'll put that on the screen right now. It says, from the above, when he was about concluding a ruling, he read nearly for 2 hours and 30 minutes. I hold that the plaintiff is a blackmailer who uses blackmail to extort money from his opponents and people he does not like. Justice Aremeyaw goes on to say, what the plaintiff is doing is not investigative journalism, but investigative terrorism. And also stated, therefore, in dismissing the defamation suit filed by Aremeyaw Anas against the Member of Parliament for Asin Central, Kennedy Agyapong. Another part here, that's what you see there. I consider it established that the plaintiff blackmails people he desires to destroy, probably his enemies or the enemies of his friends or partners or persons loaded with cash, whether legitimate or illegitimate, as a suspect in the gold scam case by catching them on tape. And then there's another one. It says the tape is then shown to them. The tape on those who pay up are shelved, but those who refuse are not able to, those who refuse or are not able to pay are held to the full glare of the public for reputational damage. And then the last one, he says such conduct is legally and morally wrong. It is evil. Based on the evidence, defendant was justified. This is Kennedy Agyapong says was justified in calling Anas evil, criminal, corrupt, blackmailer, and an extortionist. Another portion says obviously the plaintiff's case in relation to his identity suffered from internal contradiction and inconsistency. Justice Aremeyaw says, I did not find that to be the result of an unintended error or mistake. As the pleadings on both sides, the evidence of the defendant and the submission of plaintiff's own counsel shows that plaintiff was pictorially depicted in Exhibit KOA1, contrary to the denials of plaintiff's attorney and his witness. And this is the full ruling here. And we have copies of some of the court proceedings or records and how this case has traveled from 2018 to date, which we'll be putting on the screen while we go. But, the fundamental issue here, which has always been the case, really, is the modus operandi Anas uses, which Kennedy. Now, these are the copies, about 65 pages that obviously we cannot go through. But Akosiakwa mentioned the modus. That is what has been described by some people as entrapment against what undercover journalism is. And then also the point about the outcome of the modus, which is largely of public interest as against the means employed to uncover such rot in society. What is the position of the law really on all this? When many would describe, some would describe it as entrapment, others say it's undercover journalism, in relation to the outcome of this case and what Justice Eric Barr makes reference to in justifying his ruling.
Now, thank you very much. Good morning to my co-panelists, yourself, my constituents in Southern Piki, Bali, Povetong. I want us to dwell on the judgment and what it means for such issues going forward. And it's the content of the judgment that I find troubling. Because you see, there are wrongs. The law establishes wrongs. And if it's founded, there are remedies. When you wrong the state, the state doesn't bring a suit against you in defamation. The state will criminalize the conduct and prosecute you when you wrong the state. But when you wrong an individual, there are remedies. So, for instance, when I commit a wrong against my brother here, Kosiakwa, he will be a victim, but it is the state that will come against me.
Right.
But when I wrong him in a civil action, he can sue in defamation, especially if I said things to hurt his reputation. So we must be careful how we look at this matter. What is the issue? The plaintiff went to court to say that certain publications, in fact, what is material is publication. You have to publish the information to others, to the hearing of others, or for others to read. And that those publications were defamatory of his image. So he went to court. And it's not that when you go to court, you succeed all the time. Because those publications, the person can stand on any or all of some principles that we call defenses. So for instance, he could say that, well, I said so because through qualified privilege, that information came to me. And I'm putting it out to protect the public interest and public policy. We also have absolute privilege as a defense. We also have fair comment. That I am making those publications, I am saying those things, I'm putting the information out by way of fair comment. If it's established, the person will walk. There will be no remedy against him. Now, the other that you can also rely on is truth, absolute truth, justification. That you are saying that what I'm saying has actually happened, it has occurred. And so it is not defamatory of your person. Then one other that we can think of is the fact that I made a publication with your consent. You asked me to publish it. So how did I defame? You gave me the go-ahead to do it. So that's consent. And such other defenses. Now, for a judge to say that I have established that you are an extortionist in a judgment, and extortion is one of the conducts that we criminalize in this country. If you take Act 29, I believe sections 151 thereabout, we criminalize the conduct of extorting money from a third person with an intent to derive some property from the person. That is blackmail. And it's actually, if I recall, it's a second-degree felony. It's such a serious offense. So I'm wondering what will happen in this matter where a judge says that I have judicially established that you are an extortionist.
So, in fact, on that particular one, that's where the exhibit KOA 1 comes in.
Yeah.
I read that part of the ruling that said that
that's about page 60.
page 63.
2 or 3.
Yes, 62. Yes, 62.
That's
3
where
thereabout.
he analyzed the exhibits and made those
Pronouncements.
categorical judicial statements.
So this bit about extortionists, he made a reference to a tape about the ghost scam case,
Yes.
and the money that Anas was captured on tape to have said paid some former CID boss $75,000 and one other CID person $100,000. Justice Eric Barnes making the point that Anas did not make these statements under duress on the tape that they played or
that
was
was
played in
tendered.
court.
That was tendered in
As
court.
evidence.
So they become exhibits, yes. So, but I'm making a very important point, that where it is judicially established that you are an extortionist, what will happen? What will follow? Will you be prosecuted? So that is my
Who leads that prosecution?
exactly, because it's such a serious offense. So we must be careful how we say some of these things in judgment, because this judgment is by a court of appeal judge sitting as an additional high court judge, and who made this pronouncement. So it will become part of our laws. It's a court of record. Now, the issue that you raised, fundamentally, it's the weight of the evidence that were led in court. The fundamental principle underpinning our establishing evidential burden or discharging evidential burden is about relevance. It is immaterial how evidence is obtained. That's what we've been taught. It hasn't changed. I haven't seen a new doctrine or a new Supreme Court judge. Perhaps if this matter travels to the Supreme Court, it may undercut that hallowed principle right from common law, that it is immaterial how evidence is obtained. Once it is relevant, the court will look at it.
It is immaterial.
It is immaterial how you obtain evidence.
The means, the method employed.
Yes, it is immaterial how you obtain it.
Except torture.
Yes, if it is, yes, so I'm going there. If it is relevant to the matter in issue, the court will admit it and place a probative value. That's how we say it in law, probative value.
Right.
That is, the court will weigh it, lawyers will commonly say it will go in for what it is worth. But the legal term is for its probative value. That's section 51 of our Evidence Act. But 52 is very, very instructive in the sense that, yes, evidence may be relevant. It must have been obtained, no matter, irrespective of how it was obtained, it is relevant. So it should go in. But 52 will spring in when the opposing counsel can say, yes, it may be relevant. But if it goes in, it will occasion unfair prejudice to the case of my client. So it can be stopped at 52.
Okay.
Section 52 can block it. Yes, it is relevant. It's been obtained through using some means, legitimate or not, but it is relevant. But under 52, the court won't admit it because it will occasion unfair prejudice and some other standards that are stated under 52. Now, so these pieces of exhibits have gone in. They went in, they were admitted, and the judge has analyzed them and is making categorical pronouncements based on these pieces of exhibits that were tendered in. And so for me, it's very important. Does it mean that, for instance, the exhibit that you referenced?
That's a KOA 1.
Yes.
And which
Went in. And what can also happen under 52 is that it can go in, but the judge will disregard on
Right.
grounds that it's occasion unfair prejudice. So the judge,
52.
yes, 52, section 52. So the judge will not place a valuable probative value, so to speak. The probative value the judge will place on that piece of exhibit is worthless.
I see.
Yes. To found your case, the judge won't do that because it will occasion unfair prejudice.
So
It
are
will
you
prejudice
saying
the
that
case of
this
the other
KOA
party.
1, that exhibit made reference to by the judge, justifies, and indeed, even though the burden of proof shifted to Agyapong to prove indeed whether calling Anas a criminal, blackmailer, and an extortionist, that tape of the goat's calm, as made reference to in KOA 1 by the judge, justifies that particular conclusion by the judge?
I suspect the judge is proceeding under justification as a defense. You see, I gave you the different shades of defenses you can have recourse to in a defamatory matter. You are saying that I made the comments because I am justified. So how are you justified? You bear that burden to establish the justification. So if you tender documents, so again, it is immaterial how you got it. It is relevant to establishing that I made the comments justifiably as truth to the matter in question. Absolute truth. I'm just trying to establish the basis. That you see, we call it the rationale, the reasoning behind the judgment. When you enter judgment, you must give reasons for entering the judgment, and the reasons are sifted from the analysis of the pieces of exhibits that, as it were, material evidence tendered. So even though I find the analysis in many areas troubling, I'm trying to appreciate why the judge will do that. Because you see, it is not lost on me the decision of the Supreme Court that struck out, for instance, Section 53 of the NCC Act, the Narcotics Commission Act, Narcotics Control Commission Act, and the analysis that the Supreme Court made in that case, both those who were in the minority and those who were in the majority, the kind of analysis they made. So in judicial analysis, you must appreciate the rationale behind the reasoning when they are given. And so evidence is extremely important to underpin such analysis. But Justice Aremeyaw, in this matter, I find the judgment very troubling. The language in many areas, the categorical statements, he spoke more like a lawyer than for me, than a judge, because of the nature of the language. Because judges use balanced language. They use balanced language, but he was more categorical in respect of the plaintiff in the matter. But I'm happy until it goes on appeal. I'm happy that we can fairly criticize, constructively dissect the judgment.
So your trouble is with the language and
It's
some
the
of
language.
the...
To say categorically that somebody is a blackmailer, that's a crime. And this is a judicial pronouncement. That's what troubles me. If I'm a chief of the CID, I'll just be proceeding. I'll just be proceeding.
That's to effect an arrest?
Yes.
So based on this pronouncement, if the state security agency wants to proceed to arrest Anas, they could do so?
Well, a judge says he's an extortionist. Judges can actually cause to arrest in court. You know that.
Indeed.
You can go to court, and when the evidence is that you are rather a criminal, you can be, even in a civil action. I was ever in court in a land matter, and based on exhibits tendered by a party, crime had been committed, they forged the document. The judge caused the arrest of the witness immediately. Yes. Land Court 4, 2003, 2013.
I see.
Yes. Even though it was a civil matter. But the judge was of the opinion that a crime has been committed. In facial courier. That is in the face of the court. In the presence of the court, a crime has been committed. You brought forged documents to, as it were, cause the court to look elsewhere. So we must be very careful. I really find the language very troubling.
But Nelson Roxon Dafiam is a private legal practitioner. I'll come to lawyer Martin Pebu shortly, but let me bring in Manasseh Azaria. In fact, after this ruling a couple of days ago, Manasseh put out an article which he titled "Judicial Terrorism versus Investigative Terrorism," and yes, judicial terrorism against one part of it. He quotes Lord Hayward in the case of Rex v. Sussex Justices. That's a Rex versus Sussex Justices. Quoted, and I quote, "Nothing is to be done which creates even a suspicion that there has been an improper interference with the course of justice." Manasseh, if there's something this judgment has succeeded in doing, what would that be?
Well, it has succeeded in doing a number of things, and one of them, in my view, is the processes leading to the judgment. I think on the 15th of December 2021, I did a post titled "Twist and Turns in the Anas Agyapong case," and I detailed how a certain judge was transferred from the case, an interim one was brought, and when a substantive judge was appointed, Agyapong wrote to the Chief Justice saying that he needed the interim one to come back and continue. The Chief Justice granted this request without recourse to the other side of the case. And later in court, when they raised concerns, this current judge, Justice Eric Ban, actually said that the plaintiff needed to have been notified, even in Agyapong's petition to the Chief Justice, and then the Chief Justice's response, but that did not happen. So if you add that to the troubling aspect of the judgment, which Honorable Dafiam Akor has spoken so eloquently, I think that the ordinary person out there reading the judgment seems to have concerns that was this really something that was done purely based on the law, or there was an attempt to teach someone a lesson? So that is the perception among some people, and I also find parts of the language very troubling. Something emotional and tends to betray someone's real motive. So that is the basis for this article. But if you want to look at the issue in relation to investigative journalism, I think that going forward, a number of things are going to happen. One, those of us in this generation, Anas Aremeyaw Anas, the face of investigative journalism for us. He started doing great stories whilst I was in the senior high school, and a lot of those who are doing it looked up to him even whilst we're in journalism school. I remember as the SRC president of GIJ, I invited him to come and speak to students and all of that. So when these things are happening, it will affect the confidence of a number of journalists, not only in Ghana, but also in Africa and some parts of the world. That having said, the other thing that it should do for me is to refine the trade, because I will concede that we are not perfect. We have people who criticize us maliciously, some constructively, and some for different other reasons. What that does is that you look within yourself and ask, is there something that I can do about the method? Is there something I can do about my practice? So I believe the next generation of investigative journalists should begin to take not only the judgment, but the issues that have been raised, because the judgment, for some of them, I cannot speak to because I wasn't part of those investigations Anas did, and I have no idea who he met and what happened. So for some of the specific details and allegations, I think it will be inappropriate for me to want to speak to them. But generally, going forward, if there are lessons we should learn, and this did not only start with Kennedy Agyapong, Martin Amidu started a crusade and made a number of comments. So all of that, if you are an investigative journalist, what you should ask yourself is, going forward, what can I do? What can I pick from some of these public commentary? I don't think undercover method is wrong. It isn't wrong all over the world. It is used. Even state security agencies use it. Not long ago, IOCO and the Medical and Dental Council used it to be able to get people who were selling babies at the hospitals. So there's nothing wrong with undercover method. What can be wrong with undercover method, and sometimes it happens across the world, is entrapment and inducing evidence. I recently launched a book titled Investigative Journalism in Africa, a Practical Manual. And it is one of the things I discussed in that book. And my point is, when it comes to giving money in an investigation, for instance, a company has been set up and they are taking government contracts and selling. Those who buy these contracts and execute will never go forward to report this company because they are benefiting. There are certain types of corruption they call collusive corruption. Both the giver and the receiver, they benefit. So neither of them would go out there and reveal what happens within this trade. So to be able to infiltrate, you need to go in there and express interest in the contract. This is where the undercover work comes in. And because it involves selling, money has to change hands. But my policy is that don't give money unless it is demanded. If you are into undercover investigation and then you go to meet somebody and there has to be some sale or exchange of money. Don't give money until it is demanded. And sometimes the quantum of the money can even induce evidence which may not naturally have been available. So you want to establish that some prisons officers in the Sawam sell narcotics to or weed to some prisoners. Then you go there as an undercover agent, and then you present 10,000 US dollars that if you're able to get weed to this person, I will pay you this amount of money. The prisons officer you will speak to may not ordinarily be engaged in selling narcotics, but 10,000 US dollars may be too tempting to ignore. I'm not saying taking that money is right, but the amount of money, the quantum of money does not measure up with the kind of service you want the person to do. So that may end up inducing evidence which ordinarily wouldn't have been available. So this is it. Finally, I also believe in doing this kind of work, the fact that money changes hands does not necessarily mean corruption has happened. So if you want to establish whether or not the person is corrupt and in that act, at least there should be some prima facie evidence, what the lawyers call prima facie, meaning some bit of evidence that the person is already into that. And when you approach them, there should be a clear discussion of why they are demanding the money and what they intend to do after demanding it. And sometimes it isn't even enough to give the money or pay the money they are demanding, but you have to follow through and then get evidence of what they intend to do, so that when the story comes out, it should be conclusive. And finally, you do not also have to just give the money, record, but also give everybody the right of response. That we came to do this undercover, ABC, you were caught, you were doing this. Can you respond to the issues? I have had some people say, well, the person has already been captured and there's no doubt that he or she is the one in the video. But I often ask students I teach that granted that the person in the video is the one and what they are doing is not in doubt. If, for instance, you recorded somebody defecating and then you are doing a story about open defecation and you grant this person the right of response and they admit that they were the one maybe squatting behind a certain building doing it, but they show you at the time they had just left the hospital and had been diagnosed of acute diarrhea, and then they show you the diagnosis, the medicine and everything, and it corresponds with what they are saying. Would you still go ahead and put this person on television? And they say no. And I say, well, the facts have not changed, but just by listening to the other side, you may have got some understanding that shows that the person is not involved in something that you should put out. So what I am saying is that going forward, we journalists, investigative journalists, those of us who want to go undercover, an undercover method is not wrong, but it should be guided by some ethics so that it will reduce the kinds of things people say about our work. Whether your work is genuine or not, whether you are incorruptible or not, if you are into this kind of journalism that is putting people in jail, that is getting people out of jobs, that is making people lose contracts. I remember the GGA of all organizations issued a press statement against me because a story I did led to the cancellation of a $74 million contract awarded to the Just Group. It was a fraudulent contract and nobody pointed to any ethical breach. But you had the GGA writing a press statement against me. So if you are into this kind of investigation, A whole lot of things will be said about you and your work. A whole manner of allegations will be made against you, but we should do it to the best of our knowledge, the best of the application of the ethics, the best of our conscience, so that even if someone accuses you of anything, you should know that between you and your God, what you have done is clean, credible, and devoid of any malice. So going forward, I think this is what should guide us, because in every situation, whether good or bad, there are lessons we can learn. And I agree with the previous speaker that we cannot allow investigative reporting to die. It will be suicidal for us. The works of Anas, works I have done, have sent people to jail for corruption. But let's ask ourselves, the very disturbing reports from the Auditor General we find every year, how many people have gone to jail? How many people have been tried? How many top officials have lost their jobs? So investigative journalism in some way is doing more than what some state institutions paid and funded with our taxes are supposed to do. So we should be careful not to use this as an opportunity. There are people who are always looking out to discredit journalists and this critical form of reporting. And judgments like this have come to weaponize them. And so it will be a difficult time for all persons involved in this kind of journalism in this country and perhaps beyond. But I think we should look at the lessons, refine our ways, improve upon what we are already doing, and forge ahead in the interest of our dear republic.
And Manasseh, thank you. You, while talking, you make reference continuously to the ethics, even though you employ undercover means in journalism. It must be guided by the ethics. And when you make reference to Justice Eric Barnes, some of his pronouncements, he made reference to ethics as well. I see this on page 43 of the judgment. Okay, so taking into consideration your reference to the ethics, even with the employment of undercover journalism, where do we draw that fine line between the modus employed, that's the method employed in undercover journalism, and then also the ethics that you talk about, regardless, as lawyer talked about, even if the method employed is entrapment, the outcome of it is what the court is looking out for. And in most of analysis cases, if not all, the larger interest of the public is upheld. So when this case came up, a number of people who spoke during the week made reference to you, that you also do investigative journalism. You expose the rot in society in the interest of the public, which has sent people to jail, caused people to lose corrupt money, which you made reference to. But then you don't employ these other, what has been described as unorthodox means. How do we draw that fine, thin line between employing these methods of undercover journalism and upholding the ethics that you talk about?
Okay, I must say that investigative journalism involves an orthodox method. If you read journalism code of conducts across the world, they all emphasize that the straightforward means of gathering information is the preferred and orthodox and natural method that journalists should use. But they make exceptions that if you cannot use the straightforward means to get information or evidence, and if that piece of evidence or the story you intend to tell has overriding public interest considerations, you can use the unorthodox method. So if you want to go undercover, if you are recording someone without their consent, it is an unorthodox method. But within the unorthodox method, then the ethics should apply. There are people who believe that, well, once you veer into the arena of investigative reporting or undercover journalism, you should not worry about how you get the evidence. They claim the end justifies the means. I do not subscribe to this kind of journalism because sometimes you look at society, and I've just made an example of you secretly recording somebody and going out to play. But after playing, if you didn't give this person the right of response, which is an ethical requirement, after playing and embarrassing the person, you get to know that this person was diagnosed of acute diarrhea. Would you say the end has justified the means? I don't think so. Besides, you also look at, we are all human beings first before journalists. So the biblical principle that do unto others as you have them do to you should apply. And let me give you this example. I said it at my book launch recently, that in 2017, I was doing a story and I went to Nana Aremeyaw because I needed some evaluation documents on the Metro Mass buses, which the STC had done. Nana Aremeyaw is the managing director of STC. There was a man with him, a top member of one of the security agencies in Ghana. And when he saw me, that was the first time he was meeting me. So he said, are you the one we were coming to arrest? And I said, arrest for what? And this man said, well, he had led a team from the security agency he was working for to arrest me for extortion. And this was 3 or 4 years back. So I asked him where, and he mentioned the name of a private company that had sent a report that I was coming to extort money. So they laid ambush to arrest me once I stepped out of the building with the cash in hand.
I see.
And what really happened in this company was, it was when I was investigating the Judas scandal, my very first investigation. I went to do an interview, and after that, they handed a fat envelope to me with money. I don't know whether it was US dollars or cedis, that the CEO of the company, who was at the time out of the country, said they should give it to me. And I said, no, I couldn't accept this. I didn't tell them it was a bribe, but I knew it was, because I cannot take money from somebody I'm investigating. There's no way that money would be a genuine gift, even if the person intended to give me a gift. So they forced and forced, to the extent that they wanted me to speak on phone to the CEO because he would think that they did not convince me enough. I said, just tell him, I thank him, but I couldn't take the money. So while I was being almost forced to take this money, some people from the state security agencies were laying ambush to arrest me once I stepped out with this money. I could have taken this money as evidence of they wanting to compromise me or as exhibit or anything. But if I had been handcuffed and the story went out there that Manasseh went to extort money, he was arrested, the money is in his hands, whatever explanation or excuse I would give would never be accepted. And that happened to be my very first investigation. That would have been the end of my journalism career. My employers may even have fired me if that had happened. With this and other experiences, I cannot stand somewhere and defend the principle or the assertion that once you have taken the money, it means you are corrupt. I did not take it, but some may take it for different reasons, including the fact that maybe that person was not corrupt, but that day his or his wife was in the hospital and then was dying, and there was some payment that needed to be done, and the person didn't request and was given this money, and for that reason they took it. We also have a culture here of gift giving. If you even look at the American presidents, when they visit other countries and they are giving gifts, they are not supposed to take it, but when they take it, they justify that failure to accept it would embarrass the host, including gifts they took from Ghana.
Right.
So what I'm trying to say is that if you are into this kind of journalism, the fact that money has changed hands is not enough evidence that the person is corrupt or the person has done wrong. The fact that you've recorded a person doesn't say everything about the story. You need to apply ethics in this kind of reporting even more vigorously than the normal routine reporting, because the implications of this kind of journalism is dire. Some people will go to jail, people will lose their jobs, some people will die as a result of it, some people's reputations will be damaged. So I do not think that ethics shouldn't apply. It is not a thin line between ethics and undercover reporting. The line is very broad. It should never be blurred. And if you are in doubt about a person's culpability, it is better to take them out than to push them in there and then get them embarrassed. And sometimes I call something minimizing harm. When I was doing the robbing the assemblies, I secretly recorded Zoom Lions district and regional managers who were speaking so ill of the company that I take the money, doesn't even give it to them in the regions to do the work. But when I came back to Accra, I realized that I could tell the story without publishing their voices. Once I did that, these people were going to lose their jobs and livelihoods. But the story could have been told without putting them in trouble. So I took all of them out and went on to do my story. They kept their jobs, and I'm still doing my journalism because they were not those who initiated the contract. The contracts were initiated between management of Zoom Lion and government officials. So when you are doing this kind of job, I think that we need to be very careful so that when the story comes out, if somebody is going to jail, they are going to jail for something they know, even if they will not admit it publicly. Deep down within their heart, they will praise you. When Abu Gapele came out of jail and he was granted an interview in Bolga and they asked him about me, he told them that, well, he respects the kind of work I do, and he doesn't have anything against me, even though he went to jail for a story I did. So this is what I think we should do when we talk about ethics. Okay. That is not to say that I agree with everything in the judgment.
All right, great. Manasseh Azura, hold on a bit for me. Don't go off. I've just had lawyer Samid Akon is joining us on the telephone. Former lawyer of Anas Aremeyaw Anas. Samid Akon, thank you. Good morning, and thank you for joining us on Key Point.
All right, good morning, Alfred.
Yes.
Let me make a bit of disclosure that, I've been a lecturer of media law, and so I can say that I have extensive knowledge in media law, and defamation is one of the areas of my specialization. Also, at one point, I was involved in this case in which you were talking about the judgment, and like you said, I was once a lawyer for Anas. Because you were talking about entrapment and ethics at that time, let me quickly just explain something. Now, if you take Anas, for instance, he's done over 200 investigations in Ghana and across the world. You cannot even name 10 of his work where he has employed deep undercover, what we normally call subterfuge. Now, the reason why subterfuge is used in undercover journalism, and it's done not just by Anas. So when people say it's done just by Anas, it's funny. It's done globally. BBC, Al Jazeera, CNN, they all do it. The difference between that and what the security agencies do is this. Now, for investigative journalists, they will only do subterfuge when there is what we call enough predication. When we say enough predication, it means that the person should be someone that has been accused of doing something, or there should have been controversy about the person that he's involved in something. Let's say there's a person who has always been accused of being a rapist, but every time he's able to get away with it and say, I'm not a rapist, because you don't have any hardcore evidence to show he's a rapist. We will call that predication. It means there have been instances of him being accused of something. Or let's take Mr. Kwesi Nyantakyi, for example. There had been a lot of accusations that he was corrupt. And in fact, he held a press conference and challenged the media and said that if you have evidence to show I'm corrupt, bring it and I will reward you. That's why when I was lawyer for Anas at the point when this matter came, we wanted to write to the GFA to say that, and to him, that he should bring the reward. So when there is enough predication, then journalists will use what we call substance. That will not be entrapment. Entrapment is when you, Alfred, you are walking by the street. You are not known to smoke weed or marijuana. You are just walking. And somebody approaches you and says, my friend, this is weed or marijuana. Would you like to taste it? Then you pick it, you taste it, and suddenly they are on you that you are a weed or marijuana smoker. That is what we call entrapment. But if you already were suspected to be in that business and it's offered to you and you take it, that can never be entrapment, no matter where you stretch it to. And that is how come in all of Anas's case, even to the ECOWAS court, he has not been found to have breached people's privacy because what he was doing was in the public interest. Now, I will go on to this issue that has come. Now, take a few matters. I honestly think that if you don't have a complete understanding of what transpired in court, at first glance, you may believe or you may think that the judgment is sound in law and in fact, which is not. But I'll take the most controversial case which people are talking about. Now, in this case, remember that Anas himself was not present in court. He was represented by an attorney. In civil cases, you are allowed to elect someone who can stand in your stead because you are not available. So someone was in his stead. In this case, Anas called one witness in addition to his attorney. So attorney here, I'm not using attorney as a lawyer. I'm using attorney as somebody who is standing in your stead because you are not physically present in court. If you take the defendant, Kennedy, Agyapong, the MP, he had indicated he was going to call a number of witnesses, but he never called anybody. So he himself was in a box. And his evidence he brought to court were essentially the videos that he showed on his network, the different pieces of videos, about 4 of them. Now, I will say something. One, the videos which the judge heavily relied on to make criminal findings against the plaintiff, although to be able to make a criminal finding against a person, the person should have been tried and convicted, which means that it has to be a formal criminal proceedings in which the person would have been found guilty. It means he has to be present and then evidence will have to be led against him and all that. But if you notice the judgment, the judge says that the defendant had been able to prove his case beyond reasonable doubt. It means he was even talking about a criminal standard. Now, when you say beyond reasonable doubt, it means that enough evidence was led. But in this case, what was the evidence? The evidence was simply certain videos. Now, the judge and the defendant both admit that they don't know the plaintiff. In fact, in the beginning of the case, the MP said he was even not going to allow an attorney to represent the plaintiff because he wants to see his face. He does not know him. The judge also indicated that he does not know the plaintiff.
Yes.
Throughout the trial, the plaintiff's attorney said none of the videos presented shows the plaintiff. The witness that was also called to come and testify that indeed when he heard those defamatory words, these were the things that came to his mind, also said that the videos that were presented, they had not seen the plaintiff in it. Secondly, lawyers for the plaintiff also adduced evidence to show that, and during cross-examination, the defendant admitted that this tape is doctored, that this tape is not original, that this tape is not authentic, and therefore the defendant cannot speak to its production in court. Why did they say this? Because in court, when you want to put a video evidence, you are either the author of it, and if you are not the author of it, you are either producing the original of it or calling the author of it. Now, the tapes that were brought, the MP admitted that he is not the author of it. and that it is Sally's newspaper, which is the author of it.
And this includes...
He also admitted that the tapes were in different scenes.
And this
it's not a continuous tape. So one scene is here, one scene is there, so it has been cut and put together.
I see. So Samina, so this and this particular sentence you ended with is also includes the exhibit KOA1 that the judge also heavily relied on.
I'm referring to.
That exhibit KOA1.
Yeah, so I'm coming to talk about that exhibit.
That particular one, that is the gold scam case. Which was
what I'm coming to talk about.
And the judge, based on that, made reference to the details of that particular video, the payment of some $75,000.
Yes.
And then also, what did, at the time you because when this case started, you were announced as lawyer, what exactly happened in this particular video, which was tendered as evidence, which was heavily relied on by the judge?
Yes, so that is the tape I'm talking about. That. So that tape is what he heavily relied on. And he heavily relied on and used words like he's a self-confessed criminal, which means that he has confessed. Now, plaintiff says he's not the one in the video. Plaintiff's witness says he's not the one. The judge says he doesn't know the one. The MP earlier has said he doesn't know and wants to see the face of the plaintiff. So if you all don't know the person, what kind of trial took place for them to come to a determination that plaintiff is the one in the video and he's confessing to a crime? That is the question Ghanaians need to ask the court. There was no extra evidence that was tendered in court to show that, my lord, this is the plaintiff. Look at it. Just listen to the voice. Look at the face. This is the corroborating material that shows that this is the plaintiff. Moreover, I'm telling you that tape had been challenged, and the judge was made to make a ruling on it. And the judge said he was going to admit it for what it's worth, because he thinks that it's a piece of journalism work. Now, he listened to what the judge also said in judgment. He said that he wanted to believe the tape, and he admitted it because of parity of reasoning, that the plaintiff also cut and edit and show it to the world. But remember that we are in court. We are not in the world. We are not in mass media. And if you look at the plaintiff, there's not a single case that was brought against him that he has lost in court because he always produced the raw, unedited tape. But this is a judge saying that by parity of reasoning, the plaintiff does same, which is not true. Even in fact, for the judge's scandal, which the judge will know, the plaintiff was made to submit the raw, unedited tape. For number 12, in which Mr. Kwesi sued the plaintiff in court.
I see.
The plaintiff produced 100 hours of unedited tape. No wonder he ran away from those suits. For Sani Dara, the plaintiff produced raw, unedited tape to the satisfaction of Sani Dara. So there has never been a single case in court involving Anas that he presents the one that he shows outside. He always presents the raw, unedited tape. So if a judge says that by parity of reasoning, the plaintiff does the same, that cannot be true even in fact, let alone in law. But he relies on it and then admits it. So my point is that there is a problem with that tape that you are even admitting. Secondly, the plaintiff also adduced evidence to show that he did not botch that trial. The plaintiff produced documents from the Attorney General, and you can hear the judge saying that he doesn't believe the Attorney General because they are in connivance with the plaintiff, which in itself for me is an indictment from a judge to the AG. AG has presented documents to court to show that we did not botch this trial, and that is the judge involved who rather did not admit an investigation that was done by the plaintiff, which was going to be used as the sole evidence to convict the people. And that the judge, Charles Quist, rather rejected it and said he won't admit it. And so when he will not admit it, what else would the prosecution have done? And that will inform why the plaintiff later on had to investigate Charles Quist, the former judge. And in his investigation, that former judge was found to be corrupt. And so all these were presented to court. But if you read the judgment, none of that is even mentioned. With all the documents that show that there was a trial and all that, and that whatever was said in the tape cannot be true and authentic. The judge rather says that I will believe it.
Well,
so it's not even that the defendant called even further evidence to show. And the judge also keep on saying that the defendant evidence that you brought about the court trial did not have the plaintiff testify and blah blah. Meanwhile, plaintiff also accused all the court materials from the beginning of the case to the end. But even the former prosecutor who is now late, may her soul rest in peace. She resigned. She retired in 2010. The case was dismissed in 2013. So even if they were saying that it's the plaintiff in the video, on what basis could the plaintiff?
Sammy, while we round up on this, let me just say this: that because you made reference to portions of this ruling, also when you look at page 43, I read, counsel for the plaintiff referred the court to their letter, Exhibit E, which you talked about, to the Attorney General, inquiring, among others, as to whether the plaintiff testified in the case and as to, quote, whether Mrs. Ellen Kwakome and Mr. Anas could have botched the trial for it to terminate for want of prosecution. In the response, Exhibit F, which we have a copy of as we go and we'll put on the screen, the Attorney General affirmed that even though the record of proceedings does not fully reflect it, plaintiff indeed testified and was cross-examined. It also affirmed that the original prosecutor had retired by the time the case was struck out for want of prosecution. The response further stated, "We do not have anything on our records to suggest that the trial of the accused persons in the above-mentioned case was stalled or terminated by any acts perpetrated by either Ms. Ellen Kwakome or Anas Aremeyaw Anas." Was there any point that the identity of Anas was in doubt? That's number one. And there's a portion as well that reads, and I quote, "As the pleadings on both sides, the evidence of defendant and the submission of plaintiff's own counsel shows plaintiff was pictorially depicted in Exhibit KOA1, which is the gold scam evidence or exhibit that was tendered in court. Contrary to the denials of plaintiff's attorney and his witness, PW1, the denials of plaintiff through his attorney and his witness of his presence in Exhibit KO1 were deliberate falsehoods calculated to mislead the court." This is Justice Eric Barr in his ruling.
Is this not laughable? Do you see contradictions in what the judge has said? What you just read to me, show me where in what he just read, where he got that piece of evidence to say that he was pictorial. If AG says that, you first of all, it's even saying that the defendant tendered in document which shows that the plaintiff never testified. But if the plaintiff never testified, is that even an issue for the plaintiff? Is that the plaintiff's case? It's not the plaintiff's case. Plaintiff is an undercover journalist who's done a job for a company. The company has reported the matter to police, and he's only assisting as a witness. Now, the claim of the defendant is that plaintiff botched the trial. Evidence has been shown that the plaintiff never botched the trial, that even the judge rejected the evidence of the plaintiff, which is a secret recording that was supposed to be tendered in. Now, on what basis does the judge say that plaintiff has been pictorially depicted? Where? It's in the KO1. And I'm telling you that KO1, you the judge yourself says that plaintiff has denied being in it. His attorney has denied, his witness has denied being in it. Mm-hmm. You yourself as a judge says you don't know the plaintiff. The defendant in this case has said that he wants to see the face of the plaintiff to be sure whether this is the plaintiff, and so he was not going to allow an attorney. So what basis does the judge come to a conclusion? I'm saying that what was done, because the Attorney General said that plaintiff testified in court means that plaintiff is the one in the video. Where is that linkage? That is the paucity in the argument, in the reasoning.
Okay,
because
so
it doesn't add up.
In the gold
It
case,
does
in
not
this gold
add up.
scam case, was there at any point that Anas testified as Anas in this gold scam case, which the judge, that's the
You are in
KOA1?
this country. You are in this country, even for the judges scandal. Anas testified in camera. Anas has never testified in public, in the public court before. So the question you must be asking is that where did the judge come by that conclusion that plaintiff is the one in the video? Is it based on the defendant's video alone, where the defendant never brought any extra material to confirm that even that is the plaintiff? No extra material. He didn't call it. In fact, let me tell you something. There was this important ingredient in the trial that the judge consistently rejected. And that important ingredient, he was made to rule on it. It has to do with a guy called Salis. This is the guy that the defendant claims was the one who put together Who Watches the Watchman. Now, why was it important for lawyers for Anas to tender in this exhibit of the Salis person? This exhibit was simply an exhibit of the defendant himself, Mr. Agyapong, who had said that the Salis guy is evil, that the Salis guy sells things to the highest bidder.
I see. Sami Darko, thank you for the intervention. And in fact, whilst we were having the conversation, you wanted to also make a contribution or also react to some of the issues. Sami Darko is private legal practitioner. He was a lawyer for Aremeyaw Anas when this case started as far back as 2018. And that's why also he called to make an intervention. Sami Darko, appreciate it. Lawyer Martin Pebo, I'll go for this. Permit me. I'll go for a quick break.
I use
okay?
my time,
Great. Let me go for a quick break. Okay.
Yes.
Now I'll come back to you. Manasseh Azure is still with us on Zoom as well, together with both members of parliament on both sides of the divide with us as well. This is Key Point. Stay with us. We'll be back shortly after this quick break. There's more on this Anas versus Kennedy Agyapong case. A number of revelations coming out as well. Apart from what Sami Darko has indicated, there is more coming up right after this quick break. Stay with us. Welcome back to Key Point. We're live on TV3 Ghana on Facebook, DSTV channel 279, all across the world on 3news.com. We're also live on 3FM 92.7 as well. And still with me in studio, Nelson Roxon Dapiamepo is MP for South Dai, private legal practitioner. Martin Pebo is private legal practitioner, leader of one of three individual bondholder groups. Honorable Alexander Akwesiakwa is MP for Achime Odan constituency and a former media practitioner. Manasseh Azure Awoni is investigative journalist. He's with us as well on Zoom. And before the break, you heard Sami Darko, who's a private legal practitioner, a lawyer for Anas Aremeyaw Anas. When this particular case of Anas versus Kennedy Agyapong started as far back in 2018, Sami Darko was Anas's lawyer, also joining in to provide some more perspective from their point of view. Well, Martin, people, before we went for that break and the basis that Sami Darko gave and how the judge's heavy reliance on this particular KOA1 evidence led him to make a number of statements, including describing Anas in those words, or with those words, as being essentially criminal, an extortionist, a blackmailer, and an investigative terrorist. This modus that has been employed over the period, which has the public interest as the larger good, in the end, to expose the rot to the benefit of the public. Where exactly does the law talk about entrapment and that process being used to exact or extract information in an investigation for the benefit of the public?
Okay. Wow. So when you talk about
entrapment, all right, basically it's common law in origin. So you don't find it in our constitution. So when we say common law in origin, so the British brought the principles here, you know. Yes, they ruled us, and the principles as they have developed there, the case law, they used to apply here directly until finally we passed the Judicature Act, 1870 something, 1873 or so, to say that the common law that they developed did not apply automatically here. So now what happens is that if you bring a case on entrapment from the UK or any other foreign country, it's for the judge in Ghana to look at it and decide whether it applies, right? Yeah, so, and so far, we've accepted a number of cases, done a number of cases where we said there wasn't entrapment. Let's use the same ANAS. You see all the cases is done. Number 12, the biscuits case, so many of them, so many. So the entrapment, as Sami Dako sort of explained, basically, if you already have a predisposition to doing something, and then the investigator comes and offers you an opportunity to commit the crime, he's not entrapped you. You're already on your own course. You already had those proclivities. You already tended towards it. You already bent towards the crime. So it's your bending towards the crime. That, from the animals. Yes, that is what brought or drew the investigator. So you see, like Sami Dako was talking about predication. Yeah, so the journalist just doesn't get up and randomly goes to anybody. No, there should have been a controversy around you. That's the target, you say. So when that happens, you already have developed, you've already set on, by yourself a certain course of conduct that seems to say that you want or you are interested in that crime, and he comes and he makes it easier for you. It's not entrapment. So entrapment is very difficult to prove, extremely. Remember Nyantichi and his coefficient, and it's interesting, just a comment. I was wondering why Nyantichi followed his Agyapong to the court. It's like they now want to pay Anas back. No.
Well, he's been talking.
What Honorable Akwa said, we have to protect investigative journalists at all costs. We have to protect them because this is our society. The rot is too much. If we kill off Anas, Manasseh and Co., we are doomed. You know, nowadays I like to refer to Plato's Republic when you read it. And the reason, I hope in future we'll get more time to go into the genesis and the foundations of this our democracy. When you read the Republic, you see Plato, he's recounting conversations of Socrates. He talk about the society, people taking advantage of the town, the society. It's too much. It's sickening. It's sickening. It's just too much. And you could see it in the jubilation that greeted the judgment. It's like the crooked ones had now had a field day. They're jubilating all over that, yes, this guy should be clipped. That's just it. And it's too much. Look, so we'll have to, you know, kind of sit up beyond Anas and Manasseh. We should, the strong people in our society should be looking at cultivating more journalists, more investigative journalists. Otherwise, we are doomed, though. Because Alfred, if not, when Manasseh, Anas and Co., and the one who did the one that led to the resignation of the Upper West Regional Minister. Yeah, the journalists who did it. Is it Salon or something? The journalists who, those guys, I'm talking about all the investigative journalists.
Edward Adeti.
Adeti and Co. If these guys stop working, we are doomed. Look, these crooked guys will come after all of us. They will just finish us in no time. So it's in all of us our interest to continue to support Anas. By supporting Anas, we are supporting the whole of our society. Otherwise, we are finished. You see, our President Kufuor is not interested in strengthening transparency and issues in the public sector. I remember I will always mention this thing, the conduct of public officers bill. You see, because he's seeking to bring transparency so that assets will be declared and then the Shraj will have more biting teeth. He says, no, he's not interested. So that's the whole, what do you call it, setting that people will push back. So this one fits into that kind of agenda. Let's clip people who want to strengthen society. The work these investigative journalists are doing, they are strengthening society. So anybody who is not interested in strengthening society, we should see that that's an enemy.
There's an interesting point that lawyer Dafiamepo made as well earlier, and I want you to also expand it, that the law favors the method employed in exposing crime or corruption or any ills in society, except for torture.
Torture and other duress.
You can employ every other means to
undue influence. There are a number of them.
And other unorthodox means to expose corruption or rot in society.
The court will rely on it.
Yes.
And the court will not
Will
rely.
not rely on torture and undue
It may be
influence.
evidence,
Duress. Yeah,
but the court will rely on it.
Because we don't want you to go that far. So you see that entrapment. So from what lawyer Dafiamepo said, entrapment, then what happens is that, like you said, there's already controversy. So let's take which one? The number 12. So Anas knew that GFA was rotten. We all hear it. You see the coefficient Nyantichi talked about. We all knew that, look, GFA is rotten. We all know that football is full of ways and means. But we're a country where we like to cheat, age, cheating, all those things. So we all know that, look, football was so rotten. So when he went in there, he didn't go to entrap anybody. We knew it openly, ways and means. You have to buy referees and the rest. Nyantichi said that, how do you think we made it to the World Cup and the rest? So those things are out in the public there. So because of that conduct, that we already in our GFA bent towards certain conducts that are not straight. When he went in there, he didn't entrap anybody. The thing was already going on. But you hear referees who collect money and put it in their socks, all manner of things. Everyone were kids. It's been there for decades. So you see, so that's the context. That is not entrapment. That is not entrapment. When you're already on a certain course and the journalist comes, so there's that predication, there's controversy around you, there is a public reputation that you are bad in this particular area, and he comes to check, to investigate, and makes it easier for you to commit that wrongful act. That's not entrapment. And you heard what, and I want to support. You know, when Honorable Akwa was speaking, I was like, wow, for once I'd forgotten about party colors. He spoke for the nation. Yeah, Mr. Okanse. What Honorable Akwa said, he spoke for the nation. Now look, we must protect these investigative journalists. We must. We must. And you know, in order to get there, the ways, the methods that they use, it's not all of it that we understand. Corruption is not fought openly. Yes, master, are you corrupt? No, that's not how it's fought. So the way these guys do, we don't understand very well. You ask Kofi Boachi, you remember when he was in the service, people had problems with, ask him how he caught armed robbers. There are some of the things you have to play ball with them. You have to be involved even in the crime to a certain extent with them, right? That's how it is. So let's be careful. Just because you see, they say he's taking $75,000 to another person, please. You heard Manasseh say it's not conclusive. Let the case go on appeal. Yes, and let the Court of Appeal decide. And after that, we even have all the way to the Supreme Court. So that conversation will go on for long. But in the interim, what I'm bemoaning, and that's the same thing Honorable Akwa and Honorable Dafiamepo have said, is that, hey, this judgment tells you, the reactions, the jubilations tells you that our society is sick. Our society is really sick, way from the top to the bottom. Otherwise, you see, this judgment even tells you, otherwise, which country would you see that the president and finance minister are busy chopping money through data bank, and we are quiet? So, you see, larger majority, we are just bad people. That's what this judgment, the reaction tells you.
Manasseh also said that, even if you employ the unorthodox means,
yes,
the ethics must apply. So that, and he was quite consistent in making reference to, even in the realm of the employment of the unorthodox means of gathering information through journalism or undercover journalism, it does not relegate the importance and presence of the ethics that bounds the work.
Oh, definitely. Oh, everything will require ethics. That's why Honorable Dafiamepo first told you, it's not every evidence the court accepts. There's undue influence. When you say undue influence, so like the knowledge gap, like between a priest, a pastor, and a congregant, lawyer and client. So lawyer knows the law. Then you use the law to, like we say in Chi, we bring the news to take the money. So you just say the professional and the lay person, banker, customer, expand the relation. So that one, the law presumes that if you do the intake property or something, there's a presumption that you, the expert, you are wrong. Of course, you can lead evidence to rebut it. Torture, we all know. So police will take you, beat you to confess, all those things. Duress, and torture is a form of duress when you use force, etc.
Okay.
Yes. So we are saying that the ethics by all means, should be, respected. We should adhere to that. Otherwise, then it will lead to a Wild West kind of situation, right? Yeah, so we support that there should be ethics. But what we're saying is that in the meantime, you see, as I said, me not going into the judgment. No.
Do you also have challenges with the words and the expressions by the judge in this ruling?
Of course, as for some of the words, they were a bit overboard, obviously, considering that Anas is now a cultural icon. Please, let's get this very clear. So those who were jubilating, I'm like, okay, it tells you that it's not every value you create in society that the whole society will accept. If you look at the number of years he's done this work and we've accepted all the work, we will also take it that we have a strong culture of what? Investigative journalism. It's part of our culture as Ghanaians.
Corruption.
Yes, in fighting corruption. Because, and as Honorable Akwa stated it, you heard him say 2 presidents have lauded this Anas principle. President Mills and Akufo-Addo, except that Akufo-Addo is done a U-turn. But at least
Are you sure?
He's paid
Are you
lip
sure?
Oh, Akufo-Addo.
Certain.
You remember NDA matter that people, he should sack chief executive. Akufo-Addo couldn't sack. Even when the matter was in court, the man was going from his office.
But he's resigned.
It took so long. Akufo-Addo is so weak on corruption that he's so nauseating.
No.
Very nauseating. But at least he has paid lip service to the Anas principle. You remember his 18 very notable quotes that I've read a number of times here. So what we are saying is that using the Anas principle is now part of our culture. So it's too late in the day for somebody to kill it.
Okay.
Yes.
Well, so you made reference to, and I'll come to you, the GFA and this number 12 investigation, which is actually the basis for all of this, and how Agyapong also went on to put together Who Watches the Watchman and so on. The communications director of the Ghana Football Association at the time when this number 12 investigation was done, Ibrahim Sani Dara, is joining us on Zoom right now. Ibrahim Sani Dara, good morning. Thank you so much for joining us on Key Point.
Good morning, Okanse. I'm speaking on my own behalf, and to also make it clear that I take exception to some of the points made by Lawyer Kwebu and a few others to state that Anas does an honest job. And I'm going to use myself as a case that, let me make it a point that I'm also a journalist, I'm a trained journalist, I work at the highest level of world journalism and won awards for investigative journalism at the global stage. I worked for the BBC for several years. Now, investigative journalism is good for a nation. But what we have come to discover, particularly in this Anas case, is that far from what you guys, the ordinary people, will think that this guy is doing an honest job, in my case, I would say he was being dishonest, he was being criminal, and was far from the ethics of journalism, as he put it. I heard Mr. Kwebu saying that there should be a predicate to a case. In my case, for instance, what is the predicate for Anas to just creep up on me, take evidence, twist the evidence, puts it in the public face just to deceive the public and make me look like a corrupt person? And I'll state these points. I'm a communications director of the Ghana Football Association. I have no role in player selection. I have no role in selecting players to the national team. I have no influence over the coaches of the national team. I have never been linked to any case. So what was the predicate for him to swoop on me? What was the predicate? I would want to ask Martin Kwebu to answer this question for me. Now, in my case, they sent a guy. Normally, when you go to the Accra Sports Stadium, there are these guys. I mean, I'm very humble when I give gifts, and I don't say it openly. But there are these guys that you go to the stadium, you go to the VIP area, they beg for money from you. And one of those guys was the guy that was sent to me. And this guy comes to me that he wants, there's a player in Hearts of Oak called Aqua. and that he wants the player to be called to the local Black Stars, not even the Black Stars. And mind you, I was not even the spokesman for the local Black Stars then. First question I asked him, is that what you do at House of Oak? He was one of those errand boys for House of Oak. I didn't know him until, things unfolded. Then he told me he's the one that, when I come to the stadium, I gift money. And I do that a lot, not only at the stadium, but, across the places when people ask you for money. Now, this guy says, if he doesn't do it, this man, suppose agent of the player feeds him. So if he doesn't do it, he will lose his source of funding. I said, okay, come to the Accra Sports Stadium. We'll be training tomorrow in the afternoon. Come there in the open. This guy meets me in a conversation not lasting 3 minutes. In a conversation not lasting 3 minutes. I stayed there. I told him it is not possible. If anyone tells you players are called as a result of any influence, it is a lie. They will take your money, chop the money, and they won't do anything. Tell your player to work hard, do this, do that, do that. And that was the only conversation I had with them in 3 minutes. That guy, that Aqua guy who was brought to set me up with the Anas guy, they were two. And I was the only person at the Accra Sports Stadium when training was taking place. Then when immediately I finished, they tried to give me an envelope. I said, no, it is not possible. And even went to wave my hand. Do you know what Anas did? He went ahead and said Sanidara refused it, but subsequently sent his colleague to collect the bribe. Now, any person with any level of fairness or honesty would ask, one, who is that colleague of Sanidara?
Well, he said that you directed that it should be given to an unidentified man in a.
No, he said a colleague.
Yes.
That's what he said. He said a colleague. So who is that colleague? Who's that colleague of mine? Why didn't he record it? When my colleague came to him, why didn't he record the colleague saying that? And when I was saying, give it to my colleague or let my colleague come for it, why didn't he record it? So you see the dishonesty? So in that place, do you know what he did? He used captions and his own voice over. Is that journalism? That is crooked journalism. We don't need this sort of investigative journalism in Ghana. Indeed, we need investigative journalism, honest journalism. Are we not worried as a country that one journalist would wield so much power to the extent, if what Kennedy Agyapong is saying is true, that this man, this Aremeyaw guy, was the one that interviews prospective IGPs? Are we not worried that an ordinary journalist will be involved in a lot of land cases against a lot of people? Are we not worried that one journalist, you have all of these controversies and we are willy-nilly ready to hand over all of our powers to somebody who's unelected? And clearly, in my case, I speak for myself. And in my case, he clearly told the lie, as the ethics committee of the Ghana Football Association discovered. So I asked those questions. Who was that colleague of mine that I sent? Did you hear me saying my colleague of mine should come there? He should point all of these things out. So that goes to the heart of the thing. He's not honest. He tampers with evidence. He's not been honest. In my case, he was not honest.
Okay.
He was not truthful.
So, well, as we are here, we cannot, you make reference to what Kennedy Agyapong said about what Anas is involved in land cases and IGP selection. We cannot also confirm that. That's Kennedy Agyapong's words against Anas. We don't have any independent checks to confirm or deny that particular claim. But, in fact, as you stated, in the number 12, Anas did state that you indeed did not take the bribe. I remember you actually filed a suit against Anas, another defamation suit. I think some 20 million CDs you were demanding.
Yes.
Dominic Ayeni was your lawyer at the time. I remember that.
Yes.
How did that case end?
There were two cases I filed. One asking the court to declare that he illegally swooped upon me to a defamation case. Now, the first one was determined. The judge declared that Anas was in his will to swoop up or to sneak on me. Now, and in that same ruling, that judge said that we need to find the identity of that person, that other person. I was so surprised. So, like they were saying, the predicate. Where was the predicate? Am I a selector of player into the national teams? There was no predicate. That defamation case, court case has not gone anywhere. I weighed it against two things. One, the ethics committee of the Ghana Football Association. And two, going all the way and spending a lot of money. I've never been involved in, I've never been in my life, any police station for any reason. I've never been there. I've never been to court. I didn't know it was that expensive to run a defamation case. But that case is still open. And the options are still open. If I'm able to gather enough money, I will pursue it to the legal hilt. And I can say it as a matter of fact. In my case, if you guys would be grateful enough to have the tapes and ask, why is it that he said, my colleague, I sent somebody. Where in my statement did I send my colleague? Where in my state, where was that colleague of mine? Where was that colleague of mine coming there? Why didn't he have the recording? And he would rather use voiceovers and captions and subtitles to make that point when there's no evidence. If this has happened to me, perhaps it would have happened to hundreds of people who don't even know journalism, who don't know the tricks that perhaps he used. I have been violated in the most withering terms. I've been violated by this guy. And if the court has found him to be this, it has to be this. Not only that, but we have to care for journalism in Ghana. Care for journalism in Ghana. Nobody must be able to swoop up upon anybody. In India, for instance, there's a law about investigative journalism, how it is conducted. Perhaps it should not be uncontrolled. In Ghana, it is uncontrolled. Nobody can pick up any evidence on you anyhow and use it against you. You must remember the case of the News of the World in the United Kingdom. Why the News of the World newspaper was collapsed is because of some of the activities of journalists like Anas, who take evidence in one way, in an unorthodox way, and present it in an unorthodox way. That should be our concerns. As good citizens of the country, we should be happy that, investigative journalism can be used to help society, to root out corruption in society and all. But when journalism itself becomes dishonest, we must be able to call it out. And the Ghana Journalism Association must have a platform where there can be a controlled, there can be a controlled way people carry out investigative journalism. It cannot be done like the way it was done in my case. It is criminal.
Ibrahim Sanida, so I didn't get the conclusion of that defamation case. What? It's
defamation case. Yes, it's still hanging. I've not pursued it.
You haven't pursued it.
No, is that the one
I've not pursued it further.
Okay, you haven't pursued it further.
I haven't pursued it, but what is most important for me?
Okay.
No, I didn't lose the defamation case.
No, that case hasn't been concluded on as yet.
I said
there were two cases.
I took the two cases.
Yes.
One to determine whether it was illegal for Anas to swoop up upon me under no guise. Under no guise.
Yes.
That is one, and the defamation case is separate.
Okay, so that defamation case has not been ruled on as yet.
It has not, yes, it has not been forwarded because I have to pay some fees that I can't afford, or I don't even think it is wise for me to put it. Particularly when the ethics committee of the Ghana Football Association has looked at all of this evidence and decided that that claim of Anas was false and threw it out.
Okay, so yes, Lawyer Martin Pebu.
On the defamation suit. Is that not it?
There's no judgment on the defamation suit, lawyer. Can I be clear to you? Can I be
So,
clear
no,
to you?
So which one is
there was
the
a judgment
judgment?
on the
There are
first.
two
There was
cases.
the first
One,
case.
there was a
of-
first case to determine whether it was legal or illegal for Anas to swoop up upon me in this way. And even in that judgment, the lawyer said they have to identify that person in the tape. That was the Aqua guy. Why didn't the judge determine that? When I had stated...
So that's the one you lost, right?
Okay, so
Yes, that was the one I lost. That was whether it was legal or illegal. The defamation case has not been determined.
Okay.
That is how Sami Dako, that guy that came
right.
before me, is deceiving the public. And it is the way they operate, to lie and deceive.
I see. So I just wanted to establish those two cases and also the life of those two cases. So one has ended, and the other, according to Sanidara, is inconclusive because he cannot pay the legal fees, or he can't find money to pay the fees to conclude the case. Ibrahim Sanidara, thank you.
Thank you very much.
Yes, for also calling in to also make an intervention on this. Let me just state that he was the GFA communications director at the time this number 12 investigation was done by Aremeyaw, and I remember that as well. So, in that documentary, some 4,000 CDs was said to have been offered to him. That's what he makes reference to for some player selection and so on. Anas states categorically that yes, Sanidara rejected the money, but then instructed somebody, a colleague, which that's the center of this particular defamation case, that Dominic Ayene, and Honorable, your colleague in Parliament, who was then the lawyer for Sanidara, led the case sometime in June 2018. The center of this case was that who is the said colleague that Sanidara directed to go and take the money on his behalf. That case, according to Sanidara, is still running. But
do we pay 4,000 cities to influence people's inclusion in our blasters? 4,000 cities.
No. I think the essence of reference to that was for the engagement.
Oh, okay. So the engagement fee.
Yes.
The engagement fee was supposed to be the 4,000.
and he said the conversation lasted for 3 minutes.
Yes.
Okay. Yes.
Because I'm wondering whether, calling people to the Black Star, you would have to pay 4,000.
No,
4,000 is not so
it's
much.
the opportunity to have to speak with you for us to share.
Appearance fee.
Thank you.
To appear.
But you see, let's be very clear.
It's crazy.
Sanidara said something about Samida Akwe, and I think it's unfortunate. It's not a guy. It's a lawyer of good standing, of repute. He also came in and spoke about his client's case. Don't bastardize lawyers because you think they're on the other side. Tomorrow, you may go to him for a service. He didn't come here as a guy. He came here, he intervened as a lawyer and made his point. The way he was also given opportunity to intervene and make his case, however motive that is. So don't let us denigrate people unjustifiably. Now, Okanse, let me conclude my comments on this matter by saying that the judge is receiving a lot of criticism because of language. And judges also have code of conduct. Indeed, the Judicial Service of Ghana has a document or a coded guidelines directed at how our judges should conduct themselves. If you go to page 7 of the Code of Conduct for Judges, sub-guide 2 and the main guide 4, he has this to say: a judge who makes it a habit of insulting or being rude to either litigants or lawyers may lose his self-respect and may encounter rude behavior or rude language. To attempt to commit for contempt in such circumstances may tarnish the image of the judiciary and erode public confidence in the legal system. What is the code saying? By all means, adjudicate matters. By all means, enter judgment. But use decent language in doing so. Because if you insult in your judgment, if you use rude language in your judgment, it's likely the public may react in equal measure. When they do so, you will be tempted to commit for contempt, because for returning insulting language directed at you and your court. The judicial service is saying when you attempt to do that, you are rather bringing shame to the judicial service. That's one. Two, if you go to page 9 of the same code of conduct, a very major guide is given to judges, and that is guide 5. A judge shall perform judicial duties without bias or prejudice. A judge without bias or prejudice. A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice, including but not limited to bias or prejudice based upon race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, or socio-economic status, and shall require court personnel and others not to do so also. What this code is directing judges to observe is that use decorous language in entering judgment. Use this decorous language so that in entering judgment, bias and prejudice cannot be inferred from your writings.
Right.
So that you don't display prejudice in your judgment. I see a bit of prejudice in this judgment.
You see a prejudice?
I see prejudice.
Where is the prejudice?
Directed at the plaintiff.
That's Anas?
As Anas. Because of the nature of language, diction, choice of words in writing the judgment. The judgment could have been entered similarly, but using different choice of words and language. And still, the effect would have been had. That would be my concluding statement on the matter.
But appreciate it.
And for me, the reasoning is a tragedy for judicial reasoning.
It's a tragedy for what?
Yes.
Judicial what?
Reasoning.
Reasoning.
Yes. The language is too strong.
Language.
Too strong. You don't refer a party to a court as a criminal, an extortionist, a blackmailer. In a judicial write-up, in a judgment of a court, it's too strong.
Okay.
It's too strong.
I'm sure these words were used perhaps based on the kind of evidence that was adduced in court and all that. And perhaps that is what has opened this case up for discussion. And like we know, Anas has said that he's going to appeal. And by the end of maybe next week or the week preceding, I'm sure going into the case itself will let us understand why such words were used. But for me, in conclusion, I would say that Anas is exposed to this dark side of his profession because of the seeming power that he seeks to people think he's enjoying. I mean, by virtue of what he does. I mean, you've been in places where people would say, you be there, Anas is coming. You know, I mean, per what he does, he's become a celebrated hero. And so one would have expected, or one would expect that all the allegations, all the findings, all the evidence that KOA submitted to court will not, be a subject of discussion. But perhaps people are a bit surprised. People are a bit surprised with the fact that, I mean, this is somebody that we had all celebrated. How come we have this evidence? Some of us are not privy to the kind of evidence that were tendered in court. And so we want to caution all of us who are in places of authority, who are enjoying a lot of power over people, to ensure that some other person who is also watching you. And so if you're using your power against people so negatively, then you have others also watching you from the top.
Let me bring in Manasseh Azerawone also kinds of stayed with us all this while on Zoom as well. Manasseh, while we conclude on this, in the end, I mean, you've presented a very balanced picture of the employment of undercover journalism, even with the use of unorthodox means to uncover rot in the public interest. So for you, going forward with this particular outcome of the case, even though it's going to be appealed, what should be the takeaways in the coming days?
Well, the takeaways are many, but I would first start by agreeing with Mr. Aqua on the issue of power. Power is not only with those we elect into office, but a lot of people have power by virtue of what they do. There are certain places that someone would go, doors would not be open, but because it is Alfred Okanse who is seen on TV3, doors will be open. That is some form of power. So that power should not be abused. People have invested so much trust in us as journalists. So we should know how to use that trust. I was given an example somewhere about a lady I know who handed a video of a man having sex with her to me, that she went to a health facility and the man there sexually abuses women who go to that facility. She was one of them, and at one of the encounters, she recorded this man having raw sex with her. This is the most intimate part of somebody's life. So I kept wondering, why would this woman hand this to me? It is because she thinks I have earned her trust. And so that trust shouldn't be taken for granted. Having said that, I am also not oblivious of the fact that there are lots of people who are jubilating not because of anything, but because this is the time to get Anas, and it serves him right, and a whole lot of other we hear a lot of enemies. And I want to emphasize and conclude that if you are as straight as an arrow, you will have allegations made against you. If you are as crooked as a bow, you will have allegations made against you as an investigative journalist. But at the end of the day, what I think every investigative journalist and every journalist should do is that we should practice with clean hearts, clean conscience, and then treat people well. I want to emphasize again that even when there is predication that someone is susceptible to a certain kind of behavior, when you go to them, still do not offer money until they demand it. Tell them that I want, my child has to go to a school, didn't get the school they want, so what can be done? Let a person tell you that if you want the child to get the school, you have to pay money. Sometimes when you use the ethics, it even strengthens your case. In the contracts for sale, after everything, I wrote back to them, and the company's general manager confessed that he insisted that until we paid money, he wasn't going to deal with us in the first place, and that's how we paid money. So what I'm trying to say is that when we apply the ethics, sometimes it makes our case stronger. And so it is a difficult time for investigative journalists because people are using this opportunity to bastardize, insult, and attack and malign everybody. But I think if someone wants to do this kind of work, it is difficult, it is tough. You can even be killed for what you do. So what Anas is going through is even a very mild form of the persecution, and there may be difficulties an investigative journalist can go through. You can be killed for what you do, but there is nobility in standing up for what is right. There is nobility in fighting for your country. And when you have the opportunity to do that, do it honestly and be brutally truthful with your subjects and audience.
Manasseh Azuria-Wone, I thank you. Thank you very much for joining us this morning. And lawyer, I'll give you the last word, briefly.
Okay. Yeah, so I think we've said it all. As for the main point is that for the judgment, it's going on appeal. So you see, I've said I'll not go into the merits. We'll let you go on appeal, then eventually we'll have the last thing.
Indeed.
But the main thing we should be looking for is how we will cultivate more analysis. That is how our society will survive. How will we cultivate more analysis so that we'll get the analysis principle taking root firmer and firmer in our society? Because the money grabbers, the crooked ones who want to take everything for themselves, being excessively greedy, there are many. And this also tells you that even those of us who haven't had the opportunity from the jubilations, I see that it means that if we get the opportunity, we also want to behave the same way. So to the extent that majority of us in society are very bad, the way to go is that we should cultivate the analysis principle a lot more. Cultivate it well, so that we can protect ourselves.
Okay. Lawyer Martin Pebble, thank you. He's a leader of one of 3 individual bondholder groups, obviously, yes, private legal practitioner. And yes, but perhaps we cannot also independently verify the claims of data bank being used by the president and the finance minister to enrich themselves. We cannot also, and I just wanted to make that quite clear. That we cannot also cannot independently verify that particular point. I just want to make that point that we cannot also independently verify that, so as we disassociate ourselves from that. Personally and as a media house. Thank you. Okay. And we cannot also independently verify the claims by Kennedy Agyapong about Anas. But I want to thank you. Gentlemen, thank you. Nelson Roxon Dapiamepo is MP for South Dai. He is also a private legal practitioner. Thank you very much for joining us. The Member of Parliament for Achimoda constituency, Alexander Kwesiako, I appreciate your time as well. And to you, Manasseh Azuria-Wone, editor of the Fourth Estate, and then also the 2 people who called in to make an intervention. Sami Dakon, lawyer, one-time lawyer for Anas Aremeyaw Anas, and then also a lecturer, and also Ibrahim Sanidara, a former GFA spokesperson when this number 12 investigation was done. Thank you so much, gentlemen. Appreciate it. Thank you for coming.